David Roger, General Counsel for the Las Vegas Police Protective Association. In this video, it is focusing on city marshals and their contract, more specifically longevity pay. And so city marshals, I want to give you an update on where we are with longevity pay. And before we get to that, let's talk a little bit about the historical issue of longevity pay. As you know, your contract provides that all but the newest officers in the contract receive longevity pay. Generally speaking, the article provides that you are to receive 1/2 of 1% per year every year that you've been employed by the city, up to a maximum of 10%. And for some of you, that means at 20 years, you'll hit that 10%. I think that there's a second level where you have to work 24, 26 years to get to that 10%. That is the contract, that is the article. Some of the officers, some of the marshals, when they hit 20 years, recognized that they weren't getting that 10%. And so the city denied their grievances, and the city said two things. First, during the recession, there were memorandums of understanding that provided that during that period of time, you would forego your longevity pay during the recession. And then secondly, they claimed that your grievance was not timely. So the PPA took the position that the contract today doesn't reference those 2 years or 3 years during the recession in which you gave up longevity pay as a showing of good faith. The collective bargaining also has what they call a zipper clause. It's a waiver clause, and the city put that waiver clause in the contract many years ago, and the clause basically says that the CBA encompasses all of the parties' understandings, and if it's not in the CBA, then it's not enforceable. That's the city's position, and so therefore the contract is very clear. It says you get longevity pay and case closed. The city came back and said, well, you know, during that period of time, you know, you had a separate agreement. Once again, it's not part of the collective bargaining agreement. But more importantly, if a court were to look beyond the collective bargaining agreement, which parenthetically would be improper, but if the court did, the MOUs provided that you gave up longevity payments during that time, but you did not give up the accrual of credits for each year that you worked. And so you may have given up your longevity payments, but you didn't give up the accrual of that 1/2 of 1% per year of credit that you get for longevity. And so that would mean 1.5%, right? 3 years times 0.5%. So that was PPA's position with respect to the substantive issue. With respect to timeliness, the contract says that you have 30 days to file a grievance from the time that you know of a violation. There are other contracts that say that the time period begins when you knew or should have known, but that's not your contract. Your contract deals with actual knowledge, and so our position was that your grievances were timely, but more importantly, there is an exception that is adopted by some arbitrators, not all, but some arbitrators. It says that if there's a continuing violation, each day there is a new violation, and so as long as you file your grievance within that period of time, you're good to go. And so from our perspective, every day the department or the city refuses to pay longevity, it's a new grievance, it's a continuing violation. So that's where we're at. We were set to go to arbitration. We had an arbitrator selected, and the city agreed to negotiate the case. And the agreement was that those officers who had filed grievances would get a lump sum payment. It wasn't a lot of money, but nevertheless, it was a lump sum payment. When we told the city that there were other officers, other marshals who were going to be coming up on this, and that we should include them in the lump sum payment, the city rejected that, and it even went up to the city council and the mayor, and they rejected that negotiation. And so as a result, the arbitration was reset. Now, fast forward, future officers came in and filed grievances. And the city said, hey, your grievance is not timely, so we're rejecting your grievance, and we will not allow you to, or we will not agree to allow you to arbitrate the timeliness issue and the substantive issue about the contract interpretation before a single arbitrator. Well, we felt that it was retaliatory, but nevertheless, what that does is that puts the onus or the burden on us to win twice. We have to convince one arbitrator that your grievance is timely, and then we have to go before a second arbitrator and win on the substantive issue. And of course, that takes a lot of time and resources, plus it hurts our odds. We have to convince two arbitrators instead of one. And so as a result, Steve Grammas and the executive board decided that we're going to fight this in other venues. And so we filed two lawsuits concerning this issue. The first lawsuit is in district court, and that lawsuit is what we call declaratory judgment action, where we ask the court to look at the contract, look at the CBA, look at the longevity article, the waiver article, and tell us what it means. Does it mean that you get longevity, or does it mean that you get longevity minus the 1.5% that the city says that you waived during the recession? So that is the district court case. It's been filed, and we're going through litigation now. There's a second case in front of EMRB, Employee Management Relations Board. And in that lawsuit, or that complaint, we claim that the city of Las Vegas unilaterally changed our contract by requiring us to go to multiple arbitrators to grieve a single issue. The case law or EMRB's decisions say that if the contract says one thing and one side unilaterally decides to either add or subtract or change the contract, it is unilateral change and it is an unfair labor practice. So it is our position in that complaint that our grievance article is clear. It says that you may grieve an issue. It doesn't say that the city can on its own decide that you have to bifurcate or grieve different issues in front of different arbitrators. And so that is the EMRB case concerning an unfair labor practice. That is the historical part of all of this. And so we had reset the arbitration on the original grievance, and then these other employees are filing their grievances and they're working it through the process, and ultimately, unless the EMRB ruled before we got to arbitration, we'd have to go before arbitrators. The city most recently asked to continue the EMRB case, and we said that under the circumstances, the attorney was claiming or said that his family was having some medical issues. And so we told them that we want an EMRB decision. We want a decision from the district court before we go forward with any arbitrations. From our perspective, we think that we have a pretty decent shot in front of EMRB and the district court, and we believe that if we get favorable rulings in front of both, then it really is dispositive of the issue. We are, in the catbird's seat. And so we told the city that we agreed to a continuance, but we wanted to make sure that no arbitrations went before we got our court cases resolved. And the city agreed. And so today, we are continuing to litigate the EMRB case once it's reset. We are continuing to litigate the district court case. And when we get decisions from both the EMRB and the district court, then we will reset the arbitrations, and hopefully the city will agree to negotiate after they lose both cases, assuming that they do. So that is the kind of the long version of longevity. I wanted to send you this video because sometimes people don't have time to read lengthy emails, and quite frankly, I don't either. And so if you have any questions, email me at droger@lvppa.com. And of course, if you haven't subscribed to our YouTube channel, please do so. We try to keep you informed on laws and search and seizure, things that will help you do your job. Thank you very much.
111, 110.